Good afternoon. I'm Anjanette Levy, and thanks for joining us here on Law and Crime. It is Friday. Happy Friday to you. We are taking your questions about the YNW Melly case, which will be dark all of next week. And of course, we don't have court today in the trial. Melly, whose legal name is Jamell Demons, faces 2 counts of first-degree murder for the October 2018 shooting deaths of his 2 friends and YNW members, Christopher Thomas Jr. and Anthony Williams. They went by YNW Juvy and YNW Sakchaser. Melly faces the possibility of the death penalty if convicted, and he has a co-conspirator in this case. His name is Cortlen Henry. He went by, or does go by, YNW Bortlen. He will be tried separately at a later date in October, and we should let you know he was in court this morning, and we have some news about what happened there, so we'll bring that to you later in the show. But for now, keep those questions coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok, and we'll get to as many of them as we can. And we have a special 2-hour edition of the show today, so plenty of time to take your questions, and we have a great panel to do so. With me is Michael Bryant, an attorney and host here at Law and Crime. Brad Cohen is a former defense attorney of YNW Melly's, and Afi Patterson is out in California. She is an attorney and legal analyst. So thanks to everybody for being here with us today. It was a busy week in court, Michael. What were your thoughts as we wrapped up the trial this week with the testimony of the medical examiner and then Sergeant Williams, who talked about the crime scene reconstruction of this scene?
I think Sergeant Williams was a good step in the right direction for the prosecution. We and others have given them kind of a hard time through the course of their primary case. And then the MEs were interesting because they needed to hear that testimony. But I really think the focus was on this reconstructionist who focused, among other things, on how the shots fired could not have been from outside the vehicle. As we know, the defense case is basically, hey, this was just a drive-by. This is a drive-by. It wasn't Melly or anybody else inside the car firing those shots. They were on the receiving end from outside. So I think they did a great job and needed to do that for the jury to suggest to them it's ridiculous to think these shots were fired in a, quote, drive-by sense. And to that point, the MEs supported that discussion because when talking about the multiple wounds suffered by Anthony Williams and Christopher Thomas Jr., the ME was able to testify that some of the wounds took place post-mortem. So how does that work? How do you get killed in a drive-by, but some of the shots are received after you've died? I mean, that's a pretty slow drive-by if that all transpires as the evidence suggests. So I think it was a big finish for the prosecution, and they needed it.
Brad, Sergeant Williams seemed very hard to shake. It didn't seem like the defense really made any good headway with him. He seemed pretty rock solid, and they couldn't shake him no matter how hard they tried.
Certainly that was the best state witness that the state has put on to date. I had a theory when I was representing Melly about how to attack that. I think they went about it a little bit different than I would have gone about it. I believe that he's a good witness for the state. I mean, listen, I've been saying this from the beginning, and I'll say it again. Any trial is like 12 rounds of a fight, and certain rounds go one way, certain rounds go the other way. This was definitely a strong 2 days for the state. I think that the defense could have done a little bit better of a job with some of these witnesses that they put on. But don't forget, the defense is going to get a chance to put on their experts. So now they'll put on their experts that may, say, well, most likely will say that a lot of these things are not the way that it occurred or it happened, or there's different ways to take it or different ways to look at it. And that's what we're waiting for. So next week, obviously, they don't have court, but the week after, I anticipate, the defense will start putting on their witnesses probably, a couple days into the week. I think the state is essentially wrapping up. And then we'll see, again, then that's the next round, right? When the defense starts putting on witnesses. So that's how cases go. There's no such thing as slam dunk win, especially when you have a double murder case. So people that are looking on it from the outside that maybe have never tried a case or maybe don't have experience in the law are saying like, oh, they have no evidence, it's a slam dunk. There's no such thing. The state does not bring a case when they have zero evidence. They're going to have evidence. They're going to have some evidence. They're going to have some evidence that points in a certain direction. Again, They still have not put anyone on the stand that said Melly pulled the trigger, that Melly knew what was happening, that Melly was in the car at the time the gun was fired. So they still have hurdles to overcome. But certainly this is, like Mike said, a step in the right direction for the state.
Okay, well, we're going to talk a little bit later about how you would have attacked this witness, because he just seemed very cool, calm, and collected, and very confident in his results. So we'll get to that a little bit later. Jessica Trott from YouTube, Offie, I'm going to send this question to you. What was the purpose of the video surveillance from the expressway that the prosecution showed yesterday? There was zero explanation, Offie.
Well, I can just tell you what I took from it. It was a very, very late night. There weren't many people on the highway. So I think it put jurors there that night. You know, they could see what was going on. They could imagine themselves in that situation. And I think maybe the prosecution wanted them to imagine if there could possibly be a drive-by. And just to talk about what you all were discussing earlier, if we can get back to the sergeant, I think as an attorney, what we do is just drill down to the very basic language and just the very basic definition of a drive-by. I think our image of what a drive-by is has been colored by television. We see one car stationary and another car driving by. That car contains the shooter or shooters. And while the car is moving, they are shooting at another vehicle. That is what I think television has colored our image of a drive-by to be. It very well could be one car coming up in next to another, people getting out and shooting, or people shooting from another stationary vehicle. And I don't think the defense, to my knowledge and recollection, I don't think that they touched on that, but that's something that I definitely would have put to the expert yesterday.
Yeah, I think there are obviously so many different circumstances in which something could be probably categorized a so-called drive-by. So it doesn't have to just be, both cars moving, what have you. But I think you're right about that, Offie. I think that was the point. They're like, here's the video. Here's them on the expressway. Look, we don't see anybody shooting into the car. So I think that that's probably what, sometimes the prosecutors and even defense attorneys, they'll put on a piece of evidence and you're like, okay, why are they showing me this? And then they wrap it up in closing. So that may be what happens with this. Danny Jones from YouTube, question. Michael Bryant, why is Bortlen not facing the death penalty since obviously Melly is?
That's obviously a very controversial point, and many speculated, well, maybe there's some sort of deal in the works. They've taken the death penalty off the table even before he sits down to be tried in this matter. I think, again, if we follow the prosecution's arguments here, they believe perhaps he was not the trigger man or was not pulling the trigger on the fatal shots. It's still unclear because we haven't seen that case, obviously. But I think that's, it's a lesser degree of guilt in their minds and lesser deserving of the death penalty. That's all we can surmise at this point.
Mm-hmm. And maybe they think, who knows? Do they think possibly that this happens spur of the moment? It can be planned or premeditated or what have you. Maybe they think that he was taken by surprise and took part in this. I don't know. That's kind of some of the things I've been thinking about, and I've been looking at some of the comments from the viewers too, who wonder the same thing. If it went down the way the state said it did, was it premeditated, or was the planning literally in an instant, or the thought to do it? So that's kind of what I wonder about it too. Our next question is from Trinity Unique from YouTube, Brad, and she has an exclamation point. Do you think that they will drop the charges on Melly if they have not proven it's him? So, Brad, I assume you would say, no, they are not going to do that. But we know what happens at the end of the state's case.
Sure. No, they're not going to be dropping charges on Melly. At the end of the state's case, they'll move for a directed verdict, which means that, looking in the light most favorable of the state, that they haven't proven their case. Generally, on murder cases, very difficult, especially for a directed verdict, especially at that stage. And then they get another opportunity to ask for that before the jury gets the case, and it's a different burden of proof at that point. Do I think that that's going to happen? Probably not. Judges in murder cases generally let it go to the jury. because it's very difficult to DV something like that. It's just very rarely done. So no, I don't think that. I think they put on enough to this point to say that he was involved and to say that there's something going on, and then that's really all you have to get. And looking at the light most favorable to the state, that's really all you. It's a very low standard of burden for a directed verdict. I don't think that the judge would grant a directed verdict at this point.
Let's get to our next question, Afi. This one is for you. Goldman511 from YouTube asks, do the photos/videos prove it was his phone? Anyone could have saved pics of him on their phone or in Snapchat. And I'm thinking this is related to the testimony late in the day yesterday, or not really, it wasn't really even testimony. Christine Bradley published hundreds and hundreds, more than 400 photos and videos from the young Sakchaser phone that the defense has kind of disputed Melly may have had in his possession or even owned before and after the murders.
Right. And I think she wanted to leave no doubt that this was, in fact, his phone, because the phone records, it's a huge part of their case. It's what led them to what they believe is the actual crime scene, where they found casings. And the argument from the defense is that it's been a community phone. And I think the prosecution wants to put to the jury, what person would have 300, 400 plus pictures of themselves and videos and even FaceTime screenshots of themselves with other people in that phone. And I think what was really important was the absence of other people in that phone, the absence of selfies from other people who were in his group, friends, family members, or just people that we don't know. So I think that's a huge convincing evidence that was in fact his phone. And I think that she did a good job of getting that point across.
Yeah, there are definitely lots of photos and there's screen grabs, as you mentioned, where you can tell if I'm FaceTiming somebody, the little square is me, and then the big picture is the person on the other end. And there's a lot of that in there. And there's just a lot of videos of him in that phone as well. And this whole community phone argument, Brad, I'm like, really? A community phone? Do people actually really do that? I can understand you're on the same plan and everybody's got a line on the plan, maybe if you're in this rap group or whatever, but do people really pass a phone around and share it?
Again, I probably would have attacked this in a little bit of a different way. But that being said, have I seen other clients that, I've represented a lot of entertainers, not just entertainers, football players, basketball players, you name it. I've probably represented them in the past. And I have seen it done in a couple situations where there are 3 or 4 different phones that are shared between maybe 2 or 3 people, because the main person doesn't want to have his own phone or doesn't want to be accessible. So he may have someone else answering that phone or using that phone or holding that phone for him. It's not completely out of the realm of possibility. I've seen it happen. In fact, even some athletes, they'll have a couple guys around them. They may have 3 or 4 phones, and they may have their guys holding their phones for them, or their guys using their phones or calling people for reservations or things like that off those phones. So it's not so crazy and outside the realm of reality that they would do this. But I think there was probably a little bit of a modified argument that you could have made on this that would have been better. But again, I don't like second guessing anybody, because I'm not sitting there in the chair. I'm not making the arguments. I'm not making the cross examinations. Trials are very fluid, as Ophie said about the drive-by. Like, that's one thing that, when she was discussing that would be my take, to discuss what a drive-by is and what we are looking for in a drive-by. It's not the movies. It could be someone pulling up, someone getting out, someone firing, someone actually getting into the passenger seat that they might have been doing a deal with, or something else that happened, and then something goes wrong, and then a drive-by happens. There's so many other ways to explain a drive-by than simply, some car creeps by and starts firing at someone. So there's a lot of different things that could be argued in a lot of different ways. I don't like to be a Monday morning quarterback, but at the same token, you have to look at these things and you have to tweak them as it goes, because like I said, trials are very fluid and you have to be able to adapt And that's, one of the big things of great trial attorneys. They're able to adapt as they move along.
No doubt. We're going to take a quick break. Keep the questions coming in on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll get to as many of them as we can when we come back. And we're going to have that news on Cortlen Henry, YNW Bortlen, being in court this morning. So stay with us. I'm Jeanette Levy, and you're watching Law and Crime. We'll be right back. Welcome back, and thanks for being with us on this Friday afternoon. I'm Anjanette Levy. We are taking your questions for a whole 2 hours on the YNW Melly trial. He's the 24-year-old rapper accused of murdering 2 of his friends back in October of 2018. He faces 2 counts of first-degree murder in those 2018 shootings, deaths, and the possibility of the death penalty if convicted. The trial is taking place in Broward County, Florida, and it's dark today and will be dark all next week. The jury, the trial court has the week off. The judge will still be doing other things, of course. The prosecution, there are some things going on behind the scene, but no trial. There was a co-defendant in this case, a co-conspirator that we've been telling you about, and his name is Cortlen Henry. He went by YNW Bortlen, and the state claims that he basically assisted Melly in covering up this crime. When they claimed that this was a drive-by shooting. Bortlen shows up at the hospital early that morning with Christopher Williams and Anthony Williams in the vehicle, dead. Pulls up to the ER and tells the officer there, we were in a drive-by, etc. So he was in court this morning for what's called a status hearing with his attorney, and he was asking that the conditions of his bail be modified. Bortlen is currently on house arrest. So let's take a look at some of that court hearing, a little snippet of it now.
The court, when we were here the last time, you let him go to church and stuff, you said about working, you would be subject to seeing the schedule. We filed a schedule for the next couple of months.
I saw that.
And he would like to be able to work. And I talked to his probation supervisor. She has no problem with him at all. She said that if he's going to go to work, she'd like anybody has to do, provide an itinerary, where he's going to be, how he's going to get there, how it's going to get done, when he's going to be back, and the normal check-in, drug testing, everything that goes with that.
This schedule includes, locations all across the eastern seaboard and Midwest in terms of the ability to supervise for probation and pretrial, rather. That is almost impossible. With regards to the time frames and all of the studio issues on that, don't understand why they have to be until midnight or 11 p.m., why they can't be done during other hours on that. So the state would object. He's already shown prior issues with pretrial. So for those reasons, the state would say that the current schedule, and it only needs to be maintained for another 3 or 4 months at this point before we'll be in trial.
Respectfully, the motion denied. All right. Thank you.
Okay, Michael Bryant, the judge says no dice. Bortlen, you still got to stay home. You're not going to be able to travel all over the place doing shows or what have you. Yeah. So not really totally surprising.
No. But hey, this is the old rule. You don't ask, you don't get. He should be so glad just to be on house arrest. Judge, come on, I'm in the studio till after midnight. And then, cry me a river. Come on. So yeah, I'm not shocked that the modification requested was denied.
Yeah, and there's that old saying, Michael, I always think of it, nothing good happens outside after midnight. Brad,
Thanks, Mom.
This doesn't surprise me. We've seen what happens when, I guess, these guys are out after midnight, right? So I'm not surprised by this.
It doesn't surprise me, but at the same token, so representing entertainers, representing rappers, representing all these guys, their day starts at like 10 o'clock at night and goes to 6 o'clock in the morning in these studios. So it's not unusual because most of these guys are in the studios between those hours. That's just how they operate. Everybody, does their music between the hours of 10 and 6 a.m. That's their day. That's their day to day. Does it surprise me that the judge denied it? No, it doesn't surprise me. But at the same token, when the prosecutor's like, I don't understand why he has to go to the studio at midnight. That's when they go to the studio. And it's kind of like, if you're in this world, it is it's common knowledge that those are the hours that they work.
True. And I guess it's kind of like the rock star lifestyle, right? A lot of like rock bands and stuff, they work at night. But Afi, I think he is fortunate to be on house arrest, honestly. This is a double homicide case in which he's accused of helping cover up a double homicide.
Absolutely. He's fortunate to be on house arrest. These are 2 very heavy charges. And I watched the hearing this morning. I think his lawyer did what he was asked to do, but it was always going to be a safe bet that the judge was going to deny this request, this modification request, because when somebody is charged with a double homicide and someone who is their alleged co-conspirator is on trial right now, he's going to be on verdict watch soon. You're going to want to be able to put hands on the other co-conspirator just because, I think the prosecutor said today his schedule is tentative, but he may be up and down the Eastern Seaboard. You would really want to be able to know where that person is and make sure that they are within your jurisdiction when Melly's verdict comes down. So I completely understand why the judge would deny the request, but I also understand why you would want to be able to at least extend the hours that you can work, which is the studio hours, which is after 10 o'clock. That is, as you guys have already said, the creative hours.
Yeah, he might have to adjust a little bit, I guess, maybe adjust a little bit, like move it up a little bit. I mean, it kind of reminds me of when you're in college, right? You're like going out and partying and everything late at night, and it's kind of what like people that age do. I mean, am I wrong? All right, so
Not wrong.
What if Henry was a construction worker and he's working, midnight to 8, repairing roads and, doing that kind of work? Probably would have gotten an adjustment, more likely. I think there's some bias probably in the nature of the work that he does being less understood, like Brad suggests and Avi suggests. But I just thought, hey, if there are overnight workers.
Maybe you're right about that. Yeah, maybe you're right about that, Michael. If he were a construction worker doing, stuff on, like let's think about like highway work. It's summertime, you see everybody out on the highway. Sometimes they shut it down late at night or bring it down to one lane. Maybe it would be different. So maybe there is a little bias there, but we can't get inside the judge's head on that. But they said he had violated in the past too. So we'll see. We'll see what happens as his trial nears, which is going to be in October, by the way. They reiterated that today. Clowns cry gray XXX, Michael. Why is Cortlen Henry's trial date not until October? So it sounds like Clowns cry gray XXX, Michael, would like to see that trial maybe moved up a little bit. Maybe there's a reason why there's a delay by a few months, I guess.
Yeah, sometimes it's as simple as the court calendar. Once these became severed trials, they're treated as separate trials. There may also be some practical considerations with the players that are involved and the schedules. We're going to wrap this thing up, mid-July, late July. Not unreasonable to give everybody a breather for a month or two to kind of regroup and get ready for Plan B. So not a big surprise. I think actually when I heard it was October, I thought that's actually pretty quick considering all the factors.
Mm-hmm. And honestly, this case is years old now. It's almost 5 years old. So maybe it's not that, maybe it is quick, seeing that we've gotten to this point with this case. Frame from YouTube, what do you think? Will Bortlen fully snitch on Melly or just say what the defense needs? This is what Frame is asking, Brad. I don't think that if Bortlen was snitching, I think we'd know by now, right?
Yeah, I think we would know by now. Listen, again, trials are very fluid. That could change. I don't think it's going to, but certainly that could change. I don't predict him taking the stand with a pending case against himself that's going in October. I don't think he's going to be taking the stand and testifying. I would be very surprised at that. But again, things change as trials go on, and day-to-day things change, and minute-to-minute things change. Arguments are made where evidence is excluded or evidence is allowed in, and all of a sudden it changes kind of what you're going to argue and what you're going to cross-examine someone on and things of that nature. It's like that's what's so fascinating and interesting of being a trial attorney, is because it's never the same. It's always different. And within a trial, it's always different. Where you think the case is going to go, it might go in a completely different direction. And I've had cases where I thought I was sunk, and the guy insisted on going to trial, and we're picking a jury, and in my head I'm like, this is just going to be a long plea, and then things fall apart, and the state doesn't put on the right witnesses, or they don't say the right things, and then all of a sudden at the end of the day you're getting a not guilty on a case that in your head you were like, I'm probably going to lose this case, but my client really wants to go to trial. He does not want any deals. And I've seen the opposite happen, where you think, and that's why I say there's no slam dunks, where you think that the case is a great case for trial, and then things happen at trial that change the dynamics, and evidence is allowed in that you didn't think was going to be allowed in. So it's always interesting, and that's what makes this job so interesting. I think everyone that is a trial attorney will verify that.
Most definitely. You know, Bortlen's biggest challenge, I think, is going to be the fact that he gave a statement to law enforcement, because the statement does not help him at all.
No.
He talked.
No, the statement doesn't help
in the hospital.
And I'll give you a little bit of insight. Is I was representing both of them very early on, not at the hospital stage, but within a couple days of that. I was representing both just for the purposes of any kind of statement that the police may want. And obviously I was the attorney, so I wasn't going to volunteer any statements at that point. But that statement was already given. Now, does that statement help him? It depends, again, on the defense and how you're using that, and what your definition of a drive-by is, and how a drive-by could have occurred, things of that nature. But certainly saying nothing is usually the best route to take. But when you show up at a hospital and there's people that are in the car that are either passed or injured, in this case passed, but no matter what you do, if you show up at a hospital with individuals that have been shot, the police are going to want to get a statement from you. And the natural thing is to give a statement at that point, when in reality you should say, hey, listen, I don't know what's going on yet. I want to talk to my attorney first. And that's always the best advice in any type of situation, because police are usually they're not thinking to exclude you at that point. They're looking to try to include you. And any statement you give, they're going to pick it apart to include you in the amount of suspects, not exclude you from that. So that's why we always say, everyone always says, keep your mouth shut and until we find out exactly what's going on and what the police are looking at.
Well, we're going to talk more about Bortlen when we come back from this break. Keep the questions coming in on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll be right back. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Anjanette Levy, and you're watching Law and Crime. We are taking your questions for the next 2 hours on the YNW Melly case. He's the South Florida rapper on trial right now for the murders of his two friends, Chris Williams Jr. or Chris Thomas Jr., I should say, and Anthony Williams back in October of 2018. They went by YNW Juvy and YNW Sakchaser. Court is dark today, as it always is on Fridays, and no trial next week. It's a holiday week, and so that we're not going to be showing the trial next week, unfortunately, but it will be back on July 10th, and we, of course, will have it covered for you. The co-conspirator in this case, YNW Bortlen, whose legal name is Cortlen Henry, was in court today for a status hearing. The judge denied his request to modify the terms of his bail to allow him to travel for work, so he remains on house arrest. So I'm going to ask you a question about that, Afi. We got people asking questions about Cortlen Henry since he was in court today. 400 MLB from Instagram asks, how was Bortlen able to get a bond and Melly wasn't? We were kind of talking about this during the break. He's pretty lucky to be out on house arrest.
Right. Okay. So thanks, 400 ML. So usually bond, what goes into a bond, there are a lot of factors. So I am assuming, not knowing their criminal history and their background, I am assuming that Melly likely had some arrests and or probably some convictions in his on his rap sheet in his history, and I'm assuming that Bortlen did not. It's likely that he had maybe just some small, maybe misdemeanors, if anything, in his history, and that's what led a judge to allow him on house arrest. But that's usually how it goes when you have a bond. There are a lot of factors that go into it. A lot of times, depending on your jurisdiction, a particular crime is going to automatically get a bond amount, and then it's up to your attorney to argue that these are the reasons why this bond should be reduced. So yes, he is very lucky to be on house arrest and out pending his murder trial.
Danny Jones from YouTube asks, will the same prosecutors try Cortlen? I'll answer that question. Christine Bradley was in court today. She knows the case inside and out. So yes, I would say she is going to be trying this case. Unapologetic Truth from YouTube. How is Bortlen at home on a double murder charge? Brad, how did that happen?
It's essentially a thing that was just discussed. First of all, his attorney is an excellent attorney. He's very well known in Broward, good friend of mine. Fred Haddad, and he was able to negotiate a bond for him because of the charges that he was charged with, because they felt that he wasn't the trigger man, and because of his prior criminal history, which I think was very sparse. So all those things went into whether or not he was going to be given a bond. I think at the time that the bond was being argued, there was the evidence that was being presented at his bond hearing was very difficult to kind of gel together in terms of, as you've seen during the trial, right? So there's a lot of things that are going on in the trial that you're like, wait a minute, this doesn't really gel. Some things are out of whack. And that's what happens at an Arthur hearing when you're moving for bond on this type of charge. They have to put on that evidence, and sometimes they don't put on every single witness they have. And even if they do, so you're proving proof evident presumption great, which is a very high burden. And even if they meet that burden, if the state meets that burden, you're still entitled to argue for a bond. And I think that's what happened in Cortlen Henry's case, is that it was the judge felt that they just maybe barely met that burden with Cortlen Henry. And then because he had no prior criminal history, significant prior criminal history, and they were offering house arrest, that he gave him a bond.
Well, let's keep in mind, Melly has a past conviction involving a firearm as a juvenile, and he did some time for that. He fired a gun at people outside of a school. So there is that factor. He has a past history with guns. Amanda Johnson from YouTube. Michael, why not just say Bortlen was using the phone when the homicides happened?
This phone stuff, it's always very interesting. And I think, Anjanette, what we learned from Brad a little earlier is when we talked about these pass-around type phones, we don't have people. Anjanette, we need people, because then you have somebody that handles these phones for you and passes them around.
I definitely don't have an entourage.
I don't have
Michael.
people. You need people. Yeah. So, it's a good question because it highlights what I always feel is the lack of credibility of this cell phone evidence. Who was really holding it? What we know for sure is where they found it and to whose account it's attached. That's all we really know for sure. And so without some corroboration, I think these attempts to use this cell phone tracking and placement, it just doesn't really hold up for me.
It seems like, though, it's clearly his phone at the time of the homicides. I mean,
I think it's
he's
his
dropping
phone.
a pin to
I don't doubt
Fredo
that
Bangs.
it's his phone. I think it's his phone. But so what? I need more than that.
Well, she tried to give it to you yesterday,
I've
Michael.
always
She
liked
showed
Mike.
400 pictures. Yeah, Michael. Brad wants you on his juries, Michael. All right.
Mike would be my comment.
Yeah, exactly. Living Life with Danny from YouTube. Has anyone considered that Bortlen pulled over and shot both of the victims? Melly got out of the car, shocked, and got a ride from someone else. Bortlen changed clothes, then went to the hospital. That's actually a really good question. I mean, maybe Living Life with Danny Offie should be on the defense team.
Okay, so I want to get back to the fact that, so let's say the phone is his. What's after that? Show me what's next after that. The prosecution is going to have to do more than tell me that the phone was there when the murder was committed. And I think what you said about this theory, I think that's exactly what the defense wants the jurors to imagine. Imagine many different scenarios. I think right now it's hard for them because of the reconstruction expert that they had on the other day. So that's why I think the defense, while they're having this trial delay, they need to really figure out what their reconstruction expert is going to do. And I hope they have a reconstruction expert because, again, we've already said the prosecution's expert was solid, and the scenarios he gave kind of put Melly there. They put him as the trigger man. So I think the defense, what they have to do is have a reconstruction expert continue to poke holes and shape plausible other theories that could have taken place that night.
Yeah, definitely. I mean, obviously, they want them to envision multiple scenarios. So I think they will have a reconstruction, their own crime scene reconstruction person come in and say, here are these possibilities. And then the state will pick that apart, I guess. All right, next question. Brad, since you're the guy with all the inside information, Danny Jones from YouTube, is it too late for Cortlen to plea?
It's like the Justin Bieber song, It's Never Too Late to Say Sorry, I think. No, I don't think it's too late. It's never too late. I've had individuals been offered pleas but turned them down in the middle of trial. I've had people offered pleas before a verdict came back. So it just depends on the case, depends on the prosecutor, depends on the actual charges. So no, it's never too late for that. He could take a plea in the middle of his case. I don't think that would happen. If he was going to take a plea, if there was going to be a deal, it would be in the middle of Melly's case. And I want to touch on something with the experts, by the way. The defense is going to put on a display of experts, and something that maybe I would imagine that nobody knows is that there is a kind of like a Facebook for prosecutors. And what happens is during a trial or after a trial or before a trial, they go on this kind of like Facebook and they ask other prosecutors, hey, did you ever have a situation like this? Or did you ever have a situation like that? And everybody kind of gives themselves advice. So you can go on this website. It's not for us. It's only for prosecutors. You go on this website and you ask questions. So I know the prosecutor and the prosecution team has been on this website and been asking questions about coming up expert witnesses for the defense and whether or not anyone has any information about them. Does anyone have any background on them? Did anyone ever take a deposition of them that they might have screwed up? And they have this network where they will provide each other information on different experts. And on the defense side, to our credit, we have something similar, but of course not as organized as they are. And they really have that nailed down where they provide each other information on different experts and different testimony of those experts. And that's been done on this case where I don't think anybody has ever even talked about that until now.
Interesting. That is interesting. And I think very smart. I mean, it would always be smart to reach out to people, in whether you're defense or prosecution, and say, hey, have you had this expert before? Do you know anything about this person? Now that you're saying this, I think we could see possibly Sergeant Williams come back up in rebuttal then, possibly. So if the defense has their own expert and they put this person up, depending on how it goes, on cross or what have you, maybe they'll call him back up. All right, let's take a quick break. We will be right back. Keep the questions coming. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Jeanette Levy. You're watching Law and Crime, and we're taking your questions on this Friday afternoon for the next hour. So we got a 2-hour show today. It's been pretty fun so far. Keep the questions coming in. We'll get to as many of them as we can. Our next question from YouTube comes from Kat Ritter. When was the last time the state of Florida used the death penalty? Oh, that's a good question. Michael, I'll pose that one to you, but Brad, if you know the answer, let us know.
Yeah,
so Michael first, do you know?
If you have a specific date, or it's often, but I think it's been at least 5-6 years. Brad, you may know specifically.
In terms of actually putting someone to death, or in terms of asking for it? I mean, the last, in terms of asking for it, they just had, putting them to death. I wouldn't even be able to guess at that. But I would say within the past 3 years, there was probably a death. You usually hear about them, but not as often as you would think, unless it's a case of note. But the last time they sought a death penalty, I mean, they just sought the death penalty on the Parkland shooter, which they failed to obtain, and that's what changed the law from all 12 to 8 to 4 in favor of the death penalty.
Hey, Anjanette, with some help from Google, April
I was Googling
12th
too, but tell us,
this
Michael.
year, April 12th.
Oh, okay.
Of this year, it was Louis Gaskin, 56 years old, executed by lethal injection.
Okay, your Google is working better than mine because my result didn't say that. So we're going to have to complain to somebody over there at Google. All right, let's get to our next question because we've only got a short time left in this hour. Really her_TY from Twitter. Who is the witness that the prosecution and the defense spoke about deposing? What is the association to Melly? I think that was one of the people in the car, Offie, if I'm not mistaken, in the red car.
Yes. I think really is the name. I apologize for not remembering. But we were talking yesterday about the witnesses that the prosecution has had an absence of. And it's, of course, Cortlen. There are 5 people. Of course, it's Cortlen. But it's also the 4 people who were in the red vehicle. Where are they? So there was one gentleman who I don't think he could be served. And he was finally served, or there was some type of service where his mother accepted service and his sister called to find out if the deposition was going to be in person or via Skype. And I do believe either today or within the next few days, he is going to be deposed by both sides. So I don't recall his name, but it's one of the gentlemen who's riding in the red vehicle. And that's a key witness. You need that person there. He can give you direct evidence on what happened that night. And I think that's what the state has had a lack of. It's been a lot of circumstantial evidence. So we'll see if that happens, if that rolls out.
We will. That person didn't want to show up, if I recall correctly, Offie. This person was afraid. Yeah,
he said, allegedly, I'm not sure, but it was alleged that he was in fear of his life. And that's why he didn't want to show up. But I don't know the circumstances behind it. That's just hearsay. And as an attorney, I don't like hearsay. It's he say, she say. So that's just what I've heard.
Well, it was said that this person was afraid. So, which is understandable. That's some scary stuff. I mean, this is a double homicide. This is nothing to play around with. So, Brad, I heard somebody calling your name before. So, unfortunately, we're going to have to sign you off. Brad's got to go. He's got something going on. But we really appreciate you being with us. Offie's going to be here with me, and so is Michael. But we have to take this quick break. So, keep those questions coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll be right back. You are watching Law and Crime. I'm Jeanette Levy. Please stay with us. Welcome back. I'm Anjanette Levy. Thanks for being with us here on this Friday afternoon. It is almost the 4th of July weekend, so we hope everybody has a safe weekend. And we are taking your questions for the next hour on the case of YNW Melly out of Florida. He is the South Florida rapper whose legal name is Jamell Demons. We've been covering his trial now this is now the end of the 3rd week. And he is accused of murdering his 2 friends, Chris Thomas Jr. and Anthony Williams, back in October of 2018. He faces the possibility of the death penalty if convicted of these very serious crimes under a lower threshold recently signed into law by Governor Ron DeSantis in Florida. Melly has a co-conspirator. His name is Cortlen Henry. He was in court earlier today. He goes by the name YNW Bortlen. His trial is scheduled for October, and he is not facing the death penalty. We have a new guest joining us this hour. She is Mina Lona, a SiriusXM host, also hosts a radio show in Philadelphia. Afi Patterson is with us. She is a lawyer in California and a legal analyst. And Michael Bryant, an attorney and a host here at Law&Crime, is with us as well. And keep the questions coming to us on YouTube, Facebook, Twitter, Instagram, and TikTok. We'll get to as many of them as we can. So, Michael, we'll start out with this hour. Kenya Boo from Facebook asks, how did they know if Melly jumped out of the car and his friend jumped in the back seat and did that to his friends? So, interesting question there.
We all love to know that. A, if it happened, and B, where's the proof that it did? I mean, all we know from the video is that, yes, Melly got in that back seat as they left the parking lot that night, just after midnight. No, it was after 2 o'clock, like 2 something in the morning. So there's this mystery, almost 2 hours, where we don't know what happened. We only know the stories that are being told. Melly says he wasn't even in the car. Prosecution says he never left the car, and in fact, that's where he was. That's where he was seated when he fired off the weapon that killed his 2 friends. So we don't know. There is nothing hard and fast or corroborated that says Melly left the vehicle, wasn't anywhere near the vehicle when the shooting took place. That's not the prosecution's story, and the defense may claim it, but I don't see the evidence for that either. So, not their burden, though.
Afi, this next question comes to you from TikTok. Jolene Gonzalez asks, why didn't they fingerprint the phone? Yes, it was used by many, but should narrow it down. So, pretty interesting question.
Okay, so thanks, Jolene. So why didn't they fingerprint the phone? They may have fingerprinted the phone. We don't know. But what I suspect is if they did get fingerprints, it doesn't really matter, because we know Melly used the phone, and we know many other people use the phone. So it's always arguable that this is a community phone. You're going to get multiple fingerprints on the phone. So that's why I'm not saying I don't know whether they fingerprinted it or not, but I'm saying it's not dispositive. It doesn't matter, really, in this case. It wouldn't really prove anything.
Yeah, most certainly. It really wouldn't. Instagram, this question is from Junina43. What exactly was the point of Cortlen Henry's appearance? I understand they set his trial date, but it looks to me that he might take the stand. I don't know about that, but he had a very serious look on his face compared to his swagger on his IG. I will take this question. We should be talking about this later in the show, too, but he was in court for what's called a status hearing. They just bring you into court every now and then, and check in. Is everything okay? Also, he wanted the terms of his bail modified to allow him to travel to other states throughout the Midwest and on the East Coast for work. Judge Murphy said, no dice, that's not happening. So these are hearings that take place periodically. They just check in with the judge, make sure they're on track for trial, which his trial date is set for October. Aziz NX Tup _11 asks, how do you think the defense can explain the state's bullet trajectory testimony? Because that's probably the strongest evidence against Melly. Mina, do you think that they've got a way, the defense, to explain this? We know they're going to be calling their own expert.
I mean, I think Sergeant Christopher Williams was on point, and his presentation was so convincing that I actually had to reassess what I thought happened here, right? And I think we're all doing that. I think that the defense just has to put their own expert on the stand that can paint a different story. Now it's all about how do you argue back, right? That's what this is about. You present the evidence. I'm saying this is what happened. The defense is saying that is what happened. So I think if they can put another expert on the stand that can kind of go against what was laid out by Sergeant Christopher Williams, then I think maybe they can explain a different story. But Sergeant Williams was so on point, and the reconstruction and the pictures were so vivid that it would be, in my opinion, really hard to undo that unless they had another credible witness that can give another story, or expert witness or expert. Yeah.
Well, we shall see, right? So we will see when the defense starts up, and the trial is dark next week. So we'll be back with the trial on July 10th and see what else the state may have to offer there, and then go from there when the defense starts. At Tracy Have Fun from Twitter, why and how is so much evidence that is in the depositions not being allowed in trial, Michael Bryant? The jury will never hear it. It's very incriminated. How did the defense get so much evidence thrown out? So talk to us a little bit about that, Michael. This whole issue, we hear so much about depositions in this case, but this, Tracy, feels like a lot of that's not coming in.
Yeah. Well, Miss, what was it? Have fun? What was it, Tracy? Have fun?
Tracy, have fun.
Yes. Well, Miss, have fun. The deposition process is a discovery tool. And when you go through a deposition, virtually all objections are waived except to the form of a question. Okay. And what that means is there's all kinds of junk coming in a deposition that will never see the light of day in trial because they don't meet hearsay rule, foundational rules, any even relevance sometimes. Because the idea is for discovery, everything is wide open. So don't be bothering me, counsel, with some crazy objections that maybe would work at trial, because I get a chance to dig into that stuff. It may lead to something that is admissible. So don't worry about this junk over here that's not going to be admissible. Every deposition is that way, criminal, civil, it doesn't matter. It's all about finding out all the facts you can, narrowing it down, and then when you get to trial, you get to use what is truly admissible. It's very normal, but it's less juicy. I will tell you that, Ms. Have Fun. It is definitely less juicy by the time you get to trial. A lot of the good stuff's kind of chopped away.
Maybe we'll have to see if these were videotaped depositions and get those after the trial and look through them. Maybe they'd be pretty interesting. I don't know. Trelicia Mornez from YouTube asks, why are they still saying Melly might not be the shooter if only his DNA was found on the car door in the back right side? Offie.
So thank you. So they're saying he's not the shooter because, of course, the defense is saying he's not the shooter, but the prosecution has not done enough. They have not presented enough evidence to show that Melly is in fact the trigger man. And I think that they really did attempt to do that with their reconstruction expert. And I think the jurors are going to put put themselves in the situation because they are, from what I understand, going to be able to inspect the vehicle, and they're going to see, hey, how likely is it that if Melly were sitting here and someone came from the outside and either ordered him out to have pulled those shots off? Because I think the expert said that the shots were in quick succession, so there had to be one shooter. So I think that, again, the prosecution hasn't done enough right now to put the gun that they don't have yet in Melly's hand and have them pulling the trigger. But again, when the defense puts their expert on, I think that they are going to definitely put forth their own theory on what happened. And I think we kind of saw their theory when the defense counsel was cross-examining the prosecution's expert witness. I also suspect that, talking about depositions earlier, Florida is one of few states that allow depositions in criminal cases. Usually, I started my career in Louisiana. We allow, I guess you would call it a deposition if we're only trying to preserve the testimony of the witness, if we think that they're going to be unavailable in the future and not available for trial. So that's fascinating and interesting, but I suspect that from those depositions and from other evidence that's inadmissible, the prosecution has a lot of information that points to Melly, which is why they brought this very circumstantial evidence-based case to trial.
Our next question comes from Catalina from TikTok. I'll send this one over to you, Mina. What if he left that phone in the car before it happened, since he had multiple phones? And I think they're talking about the 9807 phone that we've heard so much about.
I mean, they have to prove that, right? Whatever the story is, there needs to be evidence that upholds that. So I find that when you go on social media, everyone has their theory, right? And they pick and choose different parts of the evidence to make it make sense to what they think the story is. So I think with this, we have so much circumstantial evidence. We can all have a theory and we all may be wrong. I just think that whatever it is, they need to prove it at this point.
Our next question comes from Facebook from Kodak, and I'll take this one. Was the bullet found matching Melly's Glock? There was a bullet, a single .40 caliber bullet found in the vehicle in the back seat, but there's no gun, there's no murder weapon in this case to test against, so we don't know. Plus, there was one bullet that wasn't spent, that wasn't fired. There were other shell casings, and the firearms expert in this case said, I can't say if it came from one gun or two guns, these shell casings, because I don't have a murder weapon to test. So we don't know. We don't know is the answer right there. Our next question comes from JCree23 from YouTube. If Melly was in the back seat and shot the passenger, wouldn't there be a bigger hole in the guy's head instead of a small hole from a close-up shot? Michael, all kinds of factors can impact the size of an entranced wound.
Yeah, and usually, I guess what he's thinking is if the bullet goes through the seat first and maybe starts tumbling, because that's generally what happens. The bullet stays pretty straight, and I'm no ballistics expert. It's just, you suck up some of the stuff after seeing trial after trial after trial. It starts tumbling after its path is interrupted, and if the seat did that, maybe it would have tumbled. But generally, that entrance wound is going to be small. The exit wound, that's a different story. That's where most of the damage takes place. So not uncommon to see a smaller entrance wound.
Oh, interesting. All right. Just a really horrible graphic thing to think about, those poor guys. Nicole Price from YouTube asks, if Melly is found innocent, does that help Bortlen's case? Afi, what do you think?
Thanks, Nicole. If he is acquitted, does it help his case? It does and it doesn't. I think it's going to give the prosecution, time to figure out where they went wrong in the Melly case, and they're going to use that to prepare for Cortlen's case. And they also may try and reshape their theory, reload their strategy. Who knows? But what they'll at least have is more time to prepare for Cortlen's case.
All right. Examples matter from YouTube. Question, if Bortlen changed clothes, how did the DNA blowback line up with his shirt? Mina, do you know what they're talking about there as far as any DNA that may have come from the bullet wounds blowing back? I don't recall hearing anything about that.
It's funny. That was a point of contention for me as well, because initially when this trial started, I was under the impression from the testimony of the officer that was at the hospital that there was no blood, that Cortlen was essentially clean, which was a red flag for her. And I very vividly remember her testifying to that. But as of recently, when they've introduced the Christopher Williams, the sergeant, also the medical examiner, I'm now hearing that there was something on the back of his shirt. So I myself have the same question. Was there anything on him? And is there not? And I'm confused by that as well.
Well, you would certainly think that if we saw the inside of that vehicle, if you were in a car when that happened, that you would have evidence of that on you. Living Life with Dan from YouTube. What's the difference between Bortlen being a co-conspirator versus a co-defendant? Michael, why don't you explain that for us?
Well, it's really just semantics in terms of the process. A co-conspirator is quite often a co-defendant, maybe not at the exact same time. As we know here, Melly is soloing it on this particular trial, and Henry will solo on his own in October. They're still co-conspirators, and they're still co-defendants, just not during the same proceeding. And I think in this case, and I'm thinking back to the question Offie was asked about, what would an acquittal in this case do to help or not Henry. I think you can argue it either way, like she suggests. I mean, remember, this is one of those cases, like, I didn't do it, the other guy did it, without saying that. These guys aren't going to rat on one another. But the evidence, if it's unclear, is going to allow the jury to say, well, it wasn't Demons, it had to be somebody else in the car. And then the Henry trial comes along, maybe they don't believe he did it either, had to be somebody else in the car. Either way, it's an acquittal for both guys. So it's fascinating how this is going to play out.
But aren't they considered not co-defendants because the cases were severed? Like if they were being tried together,
it's
wouldn't
a
they
semantics
be co-defendants?
It's all semantics.
Okay.
I mean, it doesn't change their legal status per se. It's not like one is a lesser defendant because they're not tried together. Yeah, they're co-conspirators being tried separately. So.
Interesting. All right. So there you have it. Keep the questions coming. We're going to take a quick break. We'll be right back. I'm Anjanette Levy, and you're watching Law and Crime. Stay with us. I'm Jeanette Levy. Thanks for being with us here on Law and Crime. We are taking your questions this hour as we always do, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok, and we'll get to as many of them as we can. Let's get to some news about Cortlen Henry, the co-conspirator in this case. He goes by the name YNW Bortlen. If you've been following the case, you know that he showed up at the hospital that night driving the two victims in this case, Chris Thomas Jr. and Anthony Williams. He shows up at the ER, says they've been the victims of a drive-by. He is also facing charges of first-degree murder in this case and being an accessory to those murders. So he was in court this morning. We got to see him in court, and he was requesting that the judge in the case modify the terms of his bail. He's right now on house arrest, but he wants to do some other things like travel for work. Take a listen.
In the court, when we were here the last time, you let him go to church and stuff, you said about working, you would be subject to seeing his schedule. We filed a schedule for the next couple of months.
I saw that.
And he would like to be able to work. And I talked to his probation supervisor. She has no problem with him at all. She said that if he's going to go to work, she'd like anybody has to do, provide an itinerary, where he's going to be, how he's going to get there, how it's going to get done, when he's going to be back, and the normal check-in, drug testing, everything that goes with that.
This schedule includes, locations all across the eastern seaboard and Midwest in terms of the ability to supervise for probation and pretrial rather. That is almost impossible. With regards to the time frames and all of the studio in issues on that, don't understand why they have to be until midnight or 11 p.m., why they can't be done during other hours on that. So the state would object. And he's already shown prior issues with pretrial. So for those reasons, the state would say that the current schedule only needs to be maintained for another 3 or 4 months at this point before we'll be in trial.
Respectfully, motion denied. All right. Thank you.
Okay, so the judge said no to the request from Cortlen Henry. He will not be able to travel due to work as he had asked. So, Afi, what did you think of this when this unfolded this morning? Cortlen Henry's trial, of course, scheduled for October, but the judge is saying, no, I'm not modifying the terms of your bail.
Well, I think, again, he was right to ask. He said he wants to work. He wants to earn money like anybody else. And his attorney properly asked the court to modify some of the terms of his probation. But again, I tend to agree with the judge. I've said this before. You want to be able to put your hands on someone if they are going to have a double murder trial within the next few months, and someone who is their alleged co-conspirator who was actually in the vehicle allegedly with them when the murder occurred is about to be on verdict watch within the next few weeks. So you want that person in town. You want to be able to put your eyes and ears on them. And as the prosecution said, he's got basically a tentative schedule. He's going to, or could possibly be up and down the eastern seaboard. Something else that I just thought about that I find really interesting is the fact that these defendants, their trials are severed. Usually in a situation like this, they would be tried together. They're both they're both being charged with double murder. But usually trials are severed when a defendant's defense is adverse to the co-defendant. And I did see some chatter. People are asking about, why does it seem like the defense could be blaming Bortlen? And I think that is because they wanted to be able to assert that it wasn't Melly and it could have been someone else and it could have been Bortlen. That's just a strategy, but I think that's something to pay attention to, and that's interesting. And that's one of the reasons why this trial is severed, or their trials are severed.
That is a very interesting point there. So it would be interesting to see what Cortlen Henry's defense will be in this case. So we should dig into that a little bit more. Deidre Covington from YouTube asked, do you think the jury is confused by all the evidence, especially yesterday from showing so many pictures? Michael, what is your take on that?
Yeah, I think a jury can be overwhelmed. There's a certain point at which you get diminished returns. And every juror is going to be different. So I'd bet that some are a little overwhelmed and confused, and others are eating it up. Because it's helping them learn more about the players in this case, and hopefully helping them get closer to a verdict. So I was a little surprised there wasn't some sort of objection for the volume of pictures. I think you could have made the same point with a whole lot fewer photos. But 300, 400 pictures, that's a lot for any jury to deal with. But I get it. You could be confused, or you could be appreciating how it's helping you get to your ultimate decision.
It was a lot of photos and a lot of videos. It just kept going and going and going, and didn't seem like it was ever going to stop. I'm going to send this one over to you, Mina, because you had mentioned this earlier. BBBB from YouTube asks, how damaging for Melly was the forensic ballistics analysis? I'm pretty sure they're referring in this question to the crime scene reconstruction expert, Sergeant Williams.
I think it was very damaging. I think that testimony, in my opinion, is the most damaging out of everything that I've seen, because it really allowed not only myself and the viewers, but also the jurors to see it, right? Sometimes we're hearing it, but it's not the same thing as to see it. And I've had questions myself about, the actual gun not being in custody, no DNA of Melly found inside, but to see the pictures and the depiction and the reconstruction and just being explained the ballistics and how it is possible for the person in the back seat to shoot both individuals at a close proximity. I think all of that was very convincing. And at this point in this particular trial, there isn't that, hey, he absolutely did it, this is the evidence. There's a lot of circumstantial evidence, and the prosecution has had the task of trying to connect those dots. And I think Sergeant Christopher Williams did an excellent job of connecting the dots and putting someone in that back seat that could have committed those murders within a close amount of time. And he was very convincing.
It was very visual. I mean, the photographs, they had somebody there holding the gun, showing how this could have unfolded, the trajectory rods, all of it. It really painted a very vivid picture for the jury. Big Head from YouTube asks, Afi, will the death penalty changes, or I think it's supposed to say charges rather, affect how the jury decides on the verdict? I think it could possibly, even though they are not supposed to be biased. So this person is wondering, because these are death qualified jurors, could that impact the verdict in what we are now in this guilt phase?
Okay. Hey, Big Head. So I definitely think
I was waiting important. For that.
You know I was going to get it. Okay, it's important because I think that the prosecution has a huge burden already. They have to prove Melly's guilt beyond any reasonable doubt, right? And I think the burden is heavier for them because now these jurors are aware that whatever they determine is weighing on a man's life, not just life in prison, not just your freedom, but your life, whether you're physically, spiritually here in this world or in the beyond, wherever that is. So I think it is going to definitely play a role. And I think that's extremely significant because the prosecution's case is super circumstantial. So they're going to have to bring it home even more. I know they're winding down on their cases, on the evidence that they're presenting, but I think they need to do a little bit more to bring it home, because you have to understand, as Nina, I believe, said, the testimony from the reconstruction expert was fantastic, and it was very powerful and very convincing. And the jurors are also going to be able to go and see what the vehicle was like, and they're going to put themselves in that situation. That's going to pull on them emotionally. So that's very powerful, but you have to understand the defense still has an opportunity. Every argument, when it's first put forth, sounds great until somebody comes along and rebuts it. So the prosecution, I think they still have a little bit more to do to cause someone to want to have on their conscience putting someone to death.
All right. We are going to take more of your questions after the break. Stay with us. Keep the questions coming on all of our social platforms, Instagram, YouTube, Twitter, Facebook, and TikTok. I'm Anjanette Levy, and you are watching Law and Crime. I'm Anjanette Levy. Welcome back, and thanks for being with us this Friday afternoon. We are taking your questions in the double murder trial of YNW Melly. And, you know, happy Friday. The court is dark on Friday and the trial is dark all week next week. So in case you didn't realize that, they're taking the week off and we'll be back on the week of July 10th. But we're still going to take your questions this hour. So we've been having a lot of fun doing it. So keep them coming. Our next question comes from Lucky from YouTube. This is for you, Michael Bryant. What will Bortlen's penalty be if he is found guilty? Will it be a life, death, sentence, or less extreme?
Yeah, well, we know the death penalty is off the table, so life without the possibility of parole, that's dripping wet, the worst thing that he might suffer if he's found guilty.
And we want to correct something that we were talking about earlier, Michael. We got some new information, right, about when the death penalty was last executed or carried out, I should say, in Florida. It happened just this month that they carried out an execution in Florida.
Yeah, two fascinating things about that. Obviously, we can't keep up with the number of death sentences carried out there. It's the fourth this year when this gentleman, Dwayne Owen, was given the lethal injection. Now, what's interesting, too, about his case was, as we've been following the death penalty's vacillations there in Florida, unanimous jury verdict, not unanimous, just recently changed from unanimous to not unanimous. Back when he committed his crimes in '84 and was convicted in '86, it was non-unanimous then as well. In fact, it wasn't until 2017 that it became a unanimous requirement, and now that has been reversed after 6 years. So his conviction was under the non-unanimous statute at the time, carried out this year just after they returned to the non-unanimous process. So the death penalty it's active in Florida, to say the least.
Okay, let's get to our next question. Leo the Frenchie Tucker from YouTube asks, why didn't the prosecution take the co-defendant to trial first, Offie, since we know for a fact that he was with the victims during the shooting? So why go with Melly first, taking him to trial first and not Bortlen?
All right, thank you, Leo. So there are lots of reasons. A lot of times it just depends on the judge and his docket, and his docket means calendar. We know that they have separate attorneys, so it could depend on when the prosecutor requested the trial date, when the judge has an availability, when the defense counsel has an availability. It depends on the different motions that are filed. So in any trial, really, there are multiple motions that can be filed and argued. So that also impacts a calendar and timing. But usually it's up to the judge, it's up to defense counsel, prosecution, and it's a matter of course, strategy and calendars and availability. Just all of those factors play into it.
Interesting. Do you think that the prosecution wanted Melly to go to trial first? Was this some type of strategy?
It may be. We do know that what they have is, well, prior to yesterday, what they have has been pretty much thin circumstantial evidence. I don't know that I would have gone with Melly first. I would have probably bet on Cortlen or Bortlen first, but that's me not sitting in the evidence and not knowing everything that they know. So again, it's strategy. But it's also up to their separate defense attorneys, their availability, the motions they file, and the judge's docket. It's a lot of things that go into it.
Mm-hmm. Interesting. Let's get to the next question here. Let's get to one, I think, from TikTok. Actually, no, let's do actually, we just asked that question. Free Stian from YouTube. What motive did he have to kill them? Mina, this has been everybody talking about this for weeks now. What's the motive? Because the defense says there is no motive. The prosecution doesn't have to prove motive. So do we have a feeling yet for why this may have occurred?
They don't have to prove murder, but it helps, especially in a case where a lot of the evidence is circumstantial. You want to know why, right? These are your lifelong friends. Melly has their names tattooed on his face. He did that before this murder. So what happened? I think it would help the jury put it all together, but I think we're all wondering the same thing. The prosecution from the beginning said they really didn't need a motive, but then introduced the gang angle. and then, started to go along the ways of, oh, well, this was for this gang initiation or because he's part of the gang. So I think they came to the realization that, hey, we do need to give a motive. I don't know if the gang angle is enough, to be honest. There's some speculation and some chatter on social media about allegedly it being involved with money. That has not been introduced into court, but we are all wondering what is the motive. And I think it would really help the prosecution for them to clearly outline a motive that makes sense. To me, saying, hey, this is a bad guy, he owns guns, and he's in a gang, that doesn't necessarily put the gun in his hand committing these two murders. So in this case, I think clearly defining that motive would really help the jury come to a conclusion.
Mm-hmm. Our next question, Michael, comes from TikTok. Stephanie Wyatt 14 asks, right, but why were messages to pick Melly up after it happened? Why did they come from Sakchaser's phone? So I think this question Stephanie has is all about the fact that the messages that Melly was sending, that the state says Melly was sending after the homicides, came from that phone labeled Young Sakchaser.
Yeah, I'm glad you say that the prosecution says he was sending, because we don't know. We don't know who was sending messages to whom, and so I think the timing is very important for both both the prosecution and the defense case. This jury has to try to put people in a particular place at a particular time to get to a particular result. And again, whether you're trying to prove the prosecution's case or the defense, I just see these stray things floating around out there, as this question suggests. They don't have a cohesive message. They don't have the pieces connected to the point where I, as a juror, would feel comfortable saying, yeah, I know that Jamell Demons killed these two guys. So this is just, to me, another example of if these questions kind of simulate what the jury might be questioning in their own minds, it's not good for the prosecution because the story has holes, a lot of holes.
I love her from TikTok. A question: when will Melly or Jamell Demons take the stand for his own self? Answer this, please. I love her with some hearts. That's her name on TikTok. Offie wants to know when Melly's going to take the stand, and she'd like an answer.
I very much so doubt that Melly is going to take the stand. We talk about this all the time. Defense attorneys discourage their clients all the time from taking the stand because from the moment that you set foot in the courtroom, everything you do until the moment you leave, people are observing you and people are critiquing you. So when he stands up, people are going to wonder, why is his posture like that? Why is he holding his head to the left or the right side? When he walks to the stand, they're going to look at his gait. Is that the gait and the posture? Is that the speed of a guilty man or an innocent man? Is he articulate when he speaks? They're going to judge him based on how he speaks, how quickly he speaks, whether he whispers or whether he's assertive. Does he sound too aggressive? Does he not sound authoritative enough? Anything that he does or says is going to be under a high level of scrutiny. And not only that, you have to really be careful because a person testifying can open the door for something that would ordinarily not be able to be let in court. So sometimes it doesn't matter how you review your client's testimony. When they get on the stand, they may want to tell their truth. You may say, hey, you have to be narrow in scope when you testify. Only answer what you're asked. Don't volunteer anything. But some defendants look at this as the only opportunity for the world to get the real story, and their opportunity to tell their truth. But in that, they open the door for maybe a prior bad act that otherwise would not have been let in. By prior bad act, I mean maybe an incident of violence that would be relevant in this case, or a former arrest or even a former conviction. So that's why unless you absolutely have to take the stand and unless your client is adamant and defiant and wants to take a stand, defense attorneys usually say, hey, sit this one out. The state has the burden. They have not met their burden. It's not necessary for you to sit on the stand and expose yourself. got out of breath on that.
Well,
so much to say about it.
Yeah. It would be really risky for him to take the stand because if we haven't heard anything about Melly's past criminal record involving firearms. So he opens himself up to that coming in if he takes the stand. Let's take a quick break. More of your great questions after we come back. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Jeanette Levy, and you are watching Law and Crime. We've got more of your questions we're taking about the YNW murder trial, so let's get right to them. Mina, this one is for you. It's from Emin of Naja from Instagram, and Emin asks, why isn't Fredo Bangs being investigated for anything? Wouldn't he be an accessory since he picked Melly up after the murders, and I would imagine his car would have the victim's blood or DNA in it? I think that's a really good question.
It is an excellent question, and the prosecutors have tried to subpoena him to have him come in and be a witness to this trial, but they have not been successful. And he actually released a song called Free Melly where he talks about that. For the past 3 years, the prosecution has tried to subpoena him, and it would be very helpful to the case to find out what's going on, but he doesn't have to come in if they're asking him. So unless they have something on him, you know, he can decline. And but I do think that it would really help this case to find out what happened if Melly is in fact innocent. But I also think when it comes to him, he might not want to implicate himself as well into this trial because it is such a very high-profile trial, and it's being followed right now.
Destiny Cobb from YouTube, Michael asks, has this idea been explored? They made a stop to see someone, rolled windows down, gun in right hand, leaning in the car, shot them both. So the angle is still coming from the back seat, but through the window.
Well, we saw that with the reconstructionist yesterday when, really anticipating the defense case, which is, hey, this happened from outside the car. It was, whether a drive-by that's really a misnomer. Maybe it was a drive, stop, shoot, and leave. But the expert went through that and had his Blue Man Group kind of act it out, and we saw the pictures of somebody outside the car reaching across and firing in the same angle that the trajectory rods suggest it would happen. It looked a little unnatural, a little weird, but not unbelievable. There's a lot of chaos going on, I would imagine, at that time. So it has been floated out there by the prosecution, anticipating that the defense is going to play with it somehow, and they probably will.
Mm-hmm. Our next question comes from Black Diamonds DC from YouTube. Afi, what happened to Melly's clothes the night of the killings?
All right. Thank you, Black Diamond. That's a fantastic question. As far as I know, we don't know what happened to his clothes the night of the killing. We don't know very much about what happened with any potential evidence that he may have had on him the night of the killing. And I think that's a deficiency in the prosecution's case. They don't have that evidence because you would expect there to be blood, DNA, and just anything that would put Melly in that vehicle and associated with the shooting that night. So we don't have that. Who knows what happened to it?
Mm-hmm. Our next question, Mina, Max Durlocker from YouTube. Has it come up in the case that Melly has bipolar disorder?
It has not, and I am really curious about that because Melly has a long background evidence that he has some mental health situations that he's dealing with. In fact, about a year before he was arrested for this murder, he was in and out of a mental institution, and he has been officially diagnosed as bipolar. We don't know if it's bipolar 1 or 2, and having ADHD. So I would imagine perhaps maybe the defense would introduce that, but I am, as you are, wondering why that hasn't come up. I don't know if their defense is going to be necessarily his mental state. From what I'm seeing, their defense is this wasn't him. He left the car before this even happened. So, but it is on record that Melly is suffering from some mental health issues. And that might be some of the things that we're seeing in his responses in court as well, that I think that the jury and even people watching at home may not understand.
But these are things that aren't relevant to this phase of the trial. Michael, say he's convicted. this may come up. The defense may talk about this in the mitigation phase or in their mitigation evidence for the penalty phase.
Yeah, no doubt about it. We've seen over history that if there's one thing juries are hesitant to do, that is sentence somebody to death if they feel is mentally challenged in some way. So you definitely would hear about it if it exists, if it's legit. If we get to a penalty phase, we'll learn all about it.
Just really quickly, we have less than a minute left. Afi, Time A Tell from YouTube. Where are Melly's alibis if he wasn't in the car?
Hi, Time A Tell. So we don't know. If he did have an alibi, he would have to file a motion and make the court aware that he had an alibi and that there was perhaps an alibi witness. And I don't think that we've seen that. And I don't think he needs to show that he has an alibi because, again, the burden is not on him. It's on the prosecution. I think the biggest issue right now is going to be motive. And I think that what the defense needs to do is shape his relationship with the
right.
It's very sad, but the victims to help. Sorry.
So we got to go. I'm so sorry to cut you off, but thank you so much, everybody, for being with us. Michael Bryant is taking over after the break. Have a great day.
And welcome back to Law and Crime. I'm Michael Bryant. Hope you had a chance to join us for our extended Q&A on the YNW Melly case. And Jeanette Levy, of course, always doing a fine job. We have some great guests and great questions. We, of course, will continue to do that. That case dark today, dark all of next week for the weird little holiday week, and then they'll be back at it, and we will continue to discuss that case. But for now, let me pivot to some other news in the world of the illegal biz here. This is a case that we've been following as well, and it resulted in an acquittal handed down yesterday in this Broward County courtroom. It's been crazy in Broward County, right? Scott Peterson, the former Parkland school officer, was on trial for, and I want you to note these charges, we're going to talk about them in detail in a moment here, child neglect and culpable negligence. This was for failing to intervene. These were alleged crimes of omission in the school shooting that took place at the Marjorie Stoneman Douglas High School back in 2018. Yesterday afternoon, the jury, after deliberating more than 19 hours, came back with a not guilty verdict on each and every of the 11 charges. Before I introduce a very special guest I have here with me, let's watch that verdict as it was handed down yesterday by the judge.
In the Circuit Court of the 17th Judicial Circuit in and for Broward County, Florida, case number 19-7166 CF10A, State of Florida plaintiff versus Scott Peterson defendant, verdict, count 1. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 2. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 3. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 4. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 5. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 6. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 7. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 8. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 9. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 10. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 11. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida.
What an emotional moment that was after a gut-wrenching 19-plus hours deliberating, waiting for this jury to come to a decision. And they did. Not guilty on all counts. Scott Peterson, the defendant there in that case. Who better to talk about this and who was sharing that very emotional moment? Mark Eiglarsh is here. Mark, I'm pretty sure you don't get tired of seeing that. What was that like?
It's still very emotional. I'm watching it, and I've been consumed with bonding with my client and family members, and in celebration and joy. And I've done interviews, but when I see it, it's only been 24 hours, so I'm very emotional every time I see it. It represents 4 years of very, very hard work against a mountain of lawyers on the other side, deep pockets. It's been really, really rough.
You know, it's maybe hard for folks who have not sat in that seat to know how connected you are to your client, to the cause. You're on the roller coaster with your client, and that's why the emotion you explain makes perfect sense, and it's a unique experience. And
let me correct you though.
Okay.
I am not sitting right next to him emotionally. Not all my clients, right? I mean, there's a difference. This one was very different. I've been doing this 30 years in spite of my extraordinarily youthful appearance. And this particular client, I believe from day one was innocent. And the evidence never pointed in any other direction. So this was a guy that I believed in, a 32-year veteran, award-winning officer, who had served his community zealously. I understood how he got to criminal charges because of the whole political sacrifice of his boss, who made a press conference to save his own butt and pointed his finger at my client to make him look like the coward of Broward County. And the truth is that was garbage. And my heart really goes out to Scott. Yes, he won, but he had 4 years of his life taken from him.
And as we watch this unfold, there really was no consensus, in my opinion, with the audience and those that were discussing this case as to what was right. And I've heard people really on both sides of that argument saying he should have done something. No, he was perfectly legitimate in what he did that day, considering the chaos. So what do you think was the motivation to bring these charges in the first place?
Okay, so you have this horrible tragedy. We all know from every tragedy comes, bad laws, people pointing fingers. In fact, there were officers on the scene who testified to me in deposition that said, you understand we're going to get blamed for this. You know that. They knew it right then and there because there had been the shooting at the airport just a few months earlier, and there's always going to be finger pointing. Then, instead of simply calling my client, former Sheriff Scott Israel, who had my client's cell phone number, who coached football at the same school that my client was at. They were friends. Instead of simply calling him because he was taking so much pressure after appearing on Jake Tapper's CNN town hall meeting, instead he has this press conference, the famous press conference where he says he should have gone in, you can't teach courage, whatever the hell else he said. Now, from that, the leader of the free world from the White House lawn now is commenting. Trump now is claiming that my client's a coward and doesn't care about kids. From that, the governor is saying we need to commence a criminal investigation. And then FDLE, Florida Department of Law Enforcement, does a shoddy investigation, leaving out exculpatory evidence, stuff that would exonerate my client, where in real time, he's saying on his radio, do you know where the shooter is? Do you know, last time we heard shots was between the 1200 and 1300 building. Nothing that indicated he knew precisely where the shots were coming from. And then prosecutors filed charges. All what I just told you, the judge wouldn't let me bring into my trial. I tried this case with my hands tied behind my back.
So you think he was a scapegoat, basically?
Everyone should think that. It's not what I think. Absolutely. And I also, again, you're dealing with emotion. Emotion and rationality are two different things. Anyone who has their doubts, watch it. Go to YouTube, Google Scott Peterson, Law and Crime, and you'll see day one, day two, go all the way through and watch it. Any rational person who watched all the testimony, who heard from over 24 defense witnesses that we presented, not the state, they didn't call these witnesses. We presented witnesses who were standing right next to my client, who heard the same shots he did, and thought 100% they were not coming from that building where the murderer was. It was coming from outside. Some people said it was at the football field, hundreds and hundreds of yards away, because of the pronounced echo and the reverberation in that area due to these massive buildings. I mean, the building we're talking about is 73 yards long. That's 3/4 of a football field. There are multiple buildings in that area. No one could tell where those shots were coming from, except a handful of people who never then communicated their thoughts to my client.
So let me ask you this. As you're going through this trial, was there a point at which you felt the tide was turning in your direction, or perhaps that you felt the prosecution was failing? Was there a moment?
Yeah, when they announced ready for trial, and I mean that. I told these jurors in jury selection, which was critical. I knew if I had just had fair jurors, we'd be good. I even told them, I said, all we're looking for is fair jurors. If we get fair jurors, We've taken depositions. There's no trial by ambush in Florida. We knew exactly what every one of their witnesses were going to say and what they weren't going to say. So I knew if they truly believed in the presumption of innocence, that my client was not guilty at the start of the trial, which is how everyone is supposed to believe, then let's go through each witness. And this is what I did in my closing argument, which you could look up and one witness at a time. Did that person convince you? What did the medical examiner convince you of? Nothing. What did that victim convince you of? Nothing. On the issue of where the shots were coming from, precisely, whoever convinced you beyond a reasonable doubt? I told them their verdict was very simple. Go back, pick a foreperson, that should take about a minute, and then the remaining 4 minutes, go around the table, and then just say, yeah, pursuant to our oath, he's not guilty. They never proved it. We never had an abiding conviction of guilt, one that does not waver or vacillate as the instructions require. And it's an easy not guilty. They stayed back another 20 hours because you got the media watching, and out of respect, they wanted to go through everything very carefully. And I respect that they did that.
Have you talked to any of the jurors since?
No, I would have been dying to do so if they didn't acquit them. But I feel very comfortable. I know exactly what they did.
Let's talk about the charges because they're bizarre. They don't apply in any situation like this. Do you think the jury understood that?
I think that they did. So they tried to make him a caregiver, which, by the way, I've been overwhelmed with emails, calls, texts from cops all over this great land saying, thank God they didn't have their way, because this would have been horrible precedent. This is a 45-acre campus. 3,200 kids on that campus. This one guy is their caregiver. This one guy then is responsible for them having a full belly of food, make sure that they're properly nourished and hydrated. He's supposed to call them in one by one every day. Turn around for me, darling. Let me make sure that you're bruise free so that you haven't suffered any abuse. Or as I used in my closing argument, okay, I'm a police officer and you're under investigation for a criminal act. You have the right to remain silent. Anything you say can and will be used against you. Hold on, before you answer, let me move closer to you. I'm your caregiver. Don't answer that question, because that could be used against you and it could jeopardize your future. He's a police officer. He's not a caregiver.
Okay, you have to understand that there are families out there that lost loved ones, and they still think that would not have happened but for your client's failure to act. You have to understand their feelings, right?
Well, of course. First of all, understand I'm in this community. We lost people that we knew about. My family, instead of doing our usual gratefuls around the dinner table, that night after the shooting, we all went around the table to talk about how it made us feel. And we decided as a family to handwrite notes to every one of these family members. And my wife, God bless her, she sent these beautiful seeds of happiness, these little ceramic smiley faces to every one of these family members. We felt it. We still feel it. But you do not do justice for all these victims by doing an injustice against my client.
What do you think this does for those in a similar situation to your client, Mr. Peterson, going forward? Is anybody going to want to be in that role ever again, knowing that school shootings do happen?
If I'm somebody thinking about being a school resource officer, I go anywhere else based upon what the prosecutors did. And quite frankly, I think this is larger than that. I'm concerned about any police officer, because these lawyers who sit in an office all day, air conditioned behind their desk with their fancy little law degrees, are going to second guess these hardworking cops who put their lives on the line every day, and then in the calmness and stillness of a courtroom, analyze what they should have done when they're experiencing auditory exclusion, their tunnel vision, adrenaline dumps, where they're not hearing things properly, they're not seeing things properly. No one should ever go through that. My client, for 4 years, wondered if he was going to spend his life in a cage for the rest of his life. Can you imagine what that's like? Horrible. It should never have happened.
So what's next for your client? How's he doing? What's the plan?
Well, we enjoyed our time together this morning. He's, both of us are like, did we dream that? He's getting used to it. He had his first night of sleep in God knows how long. And we're exploring all options, everything. People say, well, what are you going to do? Anything and everything we're exploring at this point.
So I would imagine, it wouldn't surprise me to see some movie of this whole event that focuses on his position and what he dealt with.
I don't know about that. I'm just talking about legally what we can pursue. When he was forced to resign, they took from him hundreds of hours of sick time that he's owed. So we're talking about $50,000 in sick time. Why should he forego that? And attorney's fees, there's a statute here that can reimburse him for that. Why should he be out of pocket for that based upon a baseless and meritless prosecution? So we're pursuing everything.
So, malicious prosecution, then? You think that's on the table?
Look, if it was easy to sue prosecutors, they'd be bankrupt. No, it's not easy to do that. And I think that they have enough to say in good faith they went forward. But it's very different. I met with these prosecutors. At worst, their theory was a guy shows up at the scene and in 4 minutes and 15 seconds, which is the total time he was there when the shooter was there, he froze. He had 1 minute and 6 seconds to find out where the shooting was happening and get up to the third floor of the 73-yard building to kill the killer. It's ludicrous that they would bring criminal charges. Negligence is one thing, but criminal negligence is a whole nother thing. And it never came close to that. So malicious prosecution, I would say meritless.
Well, we appreciate your time and the work that you did. Your client had Bulldog on his side. It paid off, and congratulations again on the result. Best of luck going forward, Mark.
I thank you, and it truly was my privilege to be able to defend him. It was rough. I'm still emotional.
It was
rough. It was me against the world for 3.5 years, at least. And it occupied my brain every single day. And I still just haven't had enough time to reflect. I'm going to take the 4th of July when we celebrate our freedoms and independence and our Constitution and be able to just reflect on what we were able to achieve. I'm so grateful. And thank you to you for having me. And thank you to this network.
You bet. Take care, sir. Appreciate it.
Thank you.
Okay, let's take a break, folks. We'll come back. We're going through the Scott Peterson verdict, also talking about the Melly case, which continues in that same court in Broward. So we'll come back after this. There we are. welcome back to Law and Crime, everybody. Michael Bryant here. Hey, if you just missed the interview with Mark Eiglarsh, the attorney for Scott Peterson, just acquitted, you can check that out. We'll have that clipped in on the YouTube channel before you know it. Right now, though, we're continuing to cover the murder trial of Mr. Melly in Broward. Dark today, dark all next week because of the holiday. We're going to continue to kind of bring you up to speed on where we are in this case as the prosecution really continues to bring their case to that crescendo that you might expect. This is one of the key witnesses. Everybody talking about it has said, well, if the prosecution's case has been a little flat up to date, yesterday pretty good. This is the case, of course, as you know, Demons accused of killing his two friends, Christopher Thomas Jr. And also Anthony Williams. They're rappers together. They're leaving a recording session. Somehow, this shooting takes place. The defendants claim, the defendant here in this case claims it was a drive-by. I would imagine when Cortlen Henry is tried in October, we're going to hear a similar defense. They're certainly going to be united, I think, in that defense. So some of the evidence from yesterday cleared up the huge question in this case, at least from the prosecution standpoint. They had a reconstructionist on to talk about the shots being fired. Where were they fired from? Inside the car or outside the car, a la a drive-by type shooting. So let's go in and look at some of the direct examination from this expert. He's the guy that says this shooting, man, it took place inside the vehicle. Let's watch.
How can you tell the ladies and gentlemen of this jury that, for example, shot that was marked as H in the here, let's go to 6755. How can you tell the ladies and gentlemen of the jury that shot H is not the one that wound up in the face of Mr. Thomas?
Because Mr. Thomas is already crumbling at this point, and he is actually he's in the clear, if you will, of site H.
How can you tell the ladies and gentlemen of the jury that site H is not the shot to the back of the head of Anthony Williams?
Because site H continues and strikes Anthony Williams in the shoulder.
In terms of site K, the one that goes completely across the car, how can you tell that no one was sitting in the rear driver's side seat when that bullet came through the car?
It would have hit their legs.
Was there any sign of blood or anything on that seat?
There were signs of blood on the seat, yes.
Just for the record, we are now 4875. What are we looking at in image 4875?
This is the driver's side rear compartment area with the driver's side rear passenger door in the open position.
Okay. So going forward to the next image, which is 4876, what are we looking at here?
You see that there's a reaction to blood on the door.
And so what does that tell you as a shooting reconstructionist?
It tells me that the door was closed during the shooting incident inside the vehicle.
And again, 4877.
Is the same thing.
So, Sergeant Williams, in terms of the stippling and powder tattooing that was present on Mr. Thomas, would you give a range as to how far away a muzzle would have been from his face?
The range that I would give to that would be 8 to 12 inches.
And without the actual firearm that caused that wound, could you do a recreation?
I could not, but again, like I said earlier, this is a unique case where our shooting is confined to a known area with known confinement measurements, and it can be deduced.
Christopher Williams, Sergeant Christopher Williams, doing really one heck of a job as a reconstructionist for the prosecution. And after maybe a slow start, maybe even a slow middle, prosecution seems to be finishing quite a bit stronger than the process began. Hey, I've got some great guests here with me. Former FBI agent Bobby Chacon's here, trial attorney Cortlen Lizardo as well. Both here to talk about this case and where we are at this moment. Cortlen, I can't say that you were poo-pooing the prosecution's case, because you would never do that. I probably have done that. But what do you think about this latest turn in their case? Not just the reconstructionists, but the medical examiners as well. What do you think?
Well, they are turning it up a notch, like you mentioned, and it does remind me of the Alex Murdaugh trial that we recently covered, where we felt that there was not much evidence being shown that Murdaugh committed the murder, but the prosecution ended with a bang with a lot of the other witnesses they have. It seems that's the similar strategy that the prosecution is doing here. There were a lot of doubts at the beginning as to was he the shooter? Was Jamell Demons the shooter? And how are they going to prove that? This testimony, riveting testimony by the reconstructionist, is very helpful for the jury because it's very visual and they can connect the dots finally. And that's what a reconstructionist expert usually does. That's why they're very vital at trial.
Of course, and I really think you did do a good job. And I want you to stand by here, Bobby, because I want to take a look at the cross-examination. Obviously, they're attempting to put the credibility of this expert, in jeopardy. And let's look at some of that cross-examination. We'll talk on the other side.
Part of your analysis here wasn't dealing with just trigonometry and common courtesy, that's being rude, but also your psychology of what that person would have done.
Not necessarily. So for this particular demonstrative, that is my answer. If you have somebody being rude and pointing a gun across you, I would say that you would hold you. It's human nature to hold it. You want to protect yourself. You would want to make sure that nobody gets hurt. But that didn't happen, and we don't have any blood directionality coming this way. So this scenario, although it was hoisted, is not possible.
I just want to be clear. The reason that's not possible is two reasons. One, the shooter would be being discourteous by pressing up against the person in the rear driver's seat, assuming somebody was there, rear driver's side seat. And two, because you are assuming that that person would have grabbed the arm and therefore it couldn't have happened that way. That is your science that makes this shot, not what happened.
And what you're forgetting to mention is the blowback that's on the headliner that would be part of this shooting incident, which I testified on direct that you would not have the blowback on the headliner if you had someone outside the car shooting Anthony Williams and shooting Christopher Thomas. So therefore you added rudeness, so I disagree. I agree it's rude to hold somebody up against their car like that. But at the end of the day, it's not possible, based on the blood evidence and the trajectories of this, that somebody was outside of this vehicle shooting into the vehicle.
At the end of the day, it's just not possible. It didn't happen that way.
Correct.
Okay. And I just need this jury to be clear on why, at the end of the day, the shooter was not outside.
Because we don't have the blood evidence and the trajectory.
Always gets kind of nervous when your expert says it's impossible. It is just impossible, unless it's a question like, can people fly without a plane? But in this case, this defense attorney is getting the expert to do just that. Bobby Chacon's here, Cortlen Lizardo. Bobby, what do you think about that? I understand, he wants to pin him down to make it look like, well, if you just dismiss it as totally impossible, it does affect his credibility. What do you think?
Yeah, I mean, obviously it does. I've been in that situation. I've been cross-examined by very good and competent and aggressive defense attorneys. And it is a good idea, and it's probably prudent to stay away from very definitive statements. You know, in cases like this, and a lot of forensic work, and I did 19 years of forensic work, there is science, and then there's the conclusions we make based on the science. And I think that's what the defense counsel here is trying to get at. Like, there are certain scientific things he can say. And then, based on that, you make certain kind of conclusions that must have happened because this is what the science is pointing to. And sometimes that's a short hop, and sometimes that's a bigger leap. And so the defense wants to get at, like, okay, there's science here, but your conclusions are a bit of a stretch from that science. And that's the case in almost all, you know, forensic work. And, you know, like we often hear, oh, the victim had defensive wounds, you know, because we assume when someone's come at you with a knife, you put your arm up. We don't know for a fact that those are defensive wounds. We call them that because there's a natural conclusion that when someone's coming at you with a knife, you put your hands up to protect yourself. That's a bit of a hop from the science of the medical examiner saying, here are the wounds. And then your conclusion is those are defensive wounds. So that's what's going on here. They're trying to make that hop more of a leap and undermine this expert's conclusions about what the science means.
Yeah, I thought it was interesting that they brought into the mix the rudeness of reaching across somebody to shoot somebody else with a gun. I'm not so sure if you're involved in a drive-by that politeness is top list of things you want to make sure you carry out. You know, if you're trying to kill somebody, you're going to nudge them. You know, that's not a deal. Okay, let's take a break here. We're going to have the MEs coming up in just a moment here. This is critical stuff too, because remember, some of these bullets, the MEs say, entered the bodies of the victims after they were already dead. So how does that work? We're going to get to that testimony when we come right back. Welcome back to Law and Crime. Michael Bryant here. Thanks for joining, especially on the eve of a huge weekend. When the holiday falls on a Tuesday, it's very odd, but a lot of folks are just saying, I'll take the whole week then, thank you very much. So, glad you're here. We're recapping one of the interesting cases we're covering here. This is the YNW Melly case. It is a double murder trial in Broward County. They're dark today, dark next week. While you're on vacation, they're going to be on vacation too. At least this trial will be. Some of the most important testimony for the prosecution has come from the medical examiners, one each for Anthony Williams and one for Christopher Thomas Jr. So let's start with Dr. McDougall, who performed the autopsy on Anthony Williams.
Based on your autopsy, did you come to an opinion as to the cause and manner of death for Anthony Williams?
I did.
And what was that?
The cause of death is multiple gunshot wounds, and the manner of death is homicide.
Did you recover an additional projectile from the body of Anthony Williams?
I did.
And where was that located at?
In the right scapula, or the bone, your shoulder blade, the wing of your back.
And in this next photo that we're looking at here, which is number 19, this number, is that where you retrieved that particular projectile?
That's correct. So to orient you, this is the neck, the back of the neck, the midline of the back. Okay, the entrance wound is right here. And it goes and it gets stopped by all that bone. And if you look at the muscles here, there's no hemorrhage either.
And so going on to this photo here, which is number 23, what are we looking at in that particular photo?
So that is a projectile that I recovered from the right side of the back.
Can I have a moment to consult?
Yes.
And so, Dr. McDougall, clear, we talked about B and D. Was the victim, Anthony Williams, dead when the B and D was inflicted to the body?
So when gunshot wound B was inflicted, yes, he was dead. And it exited D, so it's one gunshot wound.
Correct. So when wound C was inflicted, was Anthony Williams dead?
Yes.
I always think of remember the cop that testified, but he had a mask on, so we didn't see him. And then there was a whole thing about wearing a mask and not wearing a mask, and the jury was mad because they couldn't see him. And then there was an argument about being able to confront witnesses. So he took the mask off. We again didn't show anything but from the chest down. And then the doctor, who had just had a COVID experience, had a mask on. Anyway, that's just me. So that's Dr. Rebecca McDougall. She's performed the autopsy on Anthony Williams. Catherine Lizardo is here. Bobby Chacon here. Catherine, this is very important stuff. She said that 2 of the bullet wounds were made post-mortem, and I think I remember that means after death. So what does that mean for this jury, and how important is that tidbit?
Well, it's very critical because the defense is saying that it's a drive-by shooting, but the prosecution is saying that Melly shot them from the inside. With the shots fired after they are already dead, it leads you to believe that the drive-by shooting was actually staged. That's why her testimony was very critical. And I thought about the same thing about the mask, if I could just add how here it was acceptable and okay not to see all her facial expression while she's testifying, and the jurors didn't feel bad about that. Maybe this was something that the prosecution could have done when the undercover agent was testifying.
Yeah, it was just ironic. It had been such a hullabaloo, and then here we have the doctor who has a more credible reason to do it, in my opinion. Anyway, Bobby, stand by, because you're going to take the ME number 2, Dr. Adrienne Souter. She conducted the autopsy of Christopher Thomas Jr. So let's see what she had to say.
Okay, Dr. Souter, we were talking about the viewing of these 2 photographs. The image on the left is what?
The image on the left are the entrance wounds to the back.
And the picture on the right, what does that depict?
Those are trajectory rods in the back seat of a car.
Did you place the trajectory rods in that car?
No.
Did you go out and visit that car after rods had been placed in it at a later date?
Yes.
Based on your training and education, Can you make any opinion as to the defects that are on the body and the images and the rods in the car?
Objection. Sustained.
So, Dr. Sauter, in terms of the defects on the body, are they consistent with the defects in the car?
Objection.
Yes.
So, in terms of the other evidence that you collected, you mentioned there was foreign material from the left side of the back and the torso.
Correct.
Prior to coming into court today, did you have the opportunity to review the items of evidence and what's been marked as state quadruple C for identification purposes?
Yes.
And are they in the same or substantially same condition as when you recovered them?
Yes.
Here at this time, the state would request to move state quadruple C in as state 76.
The objection.
States quadruple C.
Hold on. No. Didn't hear an objection. No. No objection. That'll be admitted.
States quadruple C will be more state 76.
Okay, Dr. Sauter, in terms of was toxicology done on Mr. Thomas?
Yes, there was.
And were you able to provide information as to what the results of that were?
Yes.
And what were the results of the toxicology for Mr. Thomas?
He had cannabinoids in his system, which is just another word for marijuana.
Can you tell in terms of time since ingestion?
No.
Can you tell the amount that was ingested?
No.
And did you come into an opinion as to the cause of death?
Yes.
And what was that?
Multiple gunshot wounds.
And what was the manner of death?
Homicide.
Nothing further, Your Honor.
Let's see. A young star having marijuana in his system. That sounds like guilty to me. Bobby Chacon, I don't think she had quite the, pardon the phrase, smoking gun type testimony as the doctor who worked on Anthony Williams. But what do you take away from this ME as it relates to Christopher Thomas Jr.'s autopsy?
Well, you heard her talk about rods, and these are like physical wooden dowels that they kind of place through a hole in the car door and lead it to where maybe a bullet was found either in a body or in a seat of the car. So they're now saying these rods, what they do is basically trace the travel of the bullet. They use lasers sometimes. They use rods, literally physically wooden rods, to show you the travel of the bullet, how it traveled. So now they're matching up those shots to the wounds or to the defects in the car. See, there are the rods you can see on the screen now. They literally trace the path of the bullet. So it can kind of uphold the prosecution's theory that there are some that came from inside the car, which in the defense proposition there should be no shots on the inside of the car. And so that's what they're showing you. That's what this ME was saying, something about those rods, and those rods are what you saw in that image.
One of the things I wish I had learned from either doctor was how they determine a bullet entered a living body versus I know they talked about there's no blood in the muscles. I want to know the time. How much time does it take, from that first bullet entering the body, even if it's the kill shot, and she testified that the first bullet into each person was the kill shot. So how much time has to pass before the next bullet tells you it's post-mortem? Because we got this 2-hour gap that we're trying to fill with who was where and when. It would be helpful to know that, it takes at least an hour for the body to decompose or to reach post-mortem status before another bullet entering the body clearly is post-mortem. That would have been helpful for me to time it out a little bit. That's me. Maybe that'll come up. Okay, let's take a break here, guys. We'll come back more. We're kind of going over some of the Jamell Demons case. They are dark today and into next week, but defense is getting ready to put their case on. We'll be right back.
Didn't see that as condolences. What you're saying is he was saying, I was hoping I would be there to guide you in killing people. That's how you interpret that.
Yeah, I'm going to speculate again. Or do you want me to just give you my professional opinion?
Well,
because based off the way gangs operate, I can tell you.
All right, very interesting, Bobby Chacon. This is these text messages obviously could be argued either way. Which way do you think is the most realistic, the most believable?
Well, look, you have to be very familiar with these gangs in particular. Like, I was an expert in the Jamaican posses in New York City. I knew my players, I knew their language, I knew their interrelationships. I don't know this gang. So when I read this text, I thought he was giving condolences. It sounded like he knew one of his friends was involved where people were dead. Now, he's not really commenting on whether he did it or not. He's just saying, I'm sorry for your loss. So I actually read that as a sincere condolence. But this detective is claiming, and you hear the defense attorney trying to undermine that claim on cross, that this is not. He's saying, I wish I was there to help guide you. I wish I could guide you through the killing, help you kill these people. But it could be just I was there to help guide you through this whole bad scene that you're involved in.
I was trying to figure out what kind of code they might be using. I've only got about 30 seconds here, Catherine, so give me your thoughts on the importance of this masked man.
Well, this masked man has been a real big issue for us, but for now, the testimony provided about the text message might have confused the jury more, like what Bobby said, that that could have been taken both ways. So I didn't find it that helpful as well. Yeah,
it's going to be interesting to see how this shakes out. The prosecution wrapping up the week with a bang. We'll see how they do after the week off. Hey, I'm going to thank and excuse Bobby Chacon and Catherine Lizardo. Good to see you guys, as always. Have a great weekend. We'll see you next time here on the network. That's going to do it for me, Michael Bryant. Have a great holiday, however long you stretch it out. Try to do the right thing. I will see you next time right here on Law and Crime.